Are you on? Hold on a second, Bruce.
Good? Okay. So it's really important. I know sometimes you think, oh, compliance stuff, it's really boring. But as Dr. Wren had said, you guys interact with the patients all the time. And if patients are upset about something, patients are confused about something, patients don't understand something, they're going to look for a way to exploit Jersey Urology Group and say, one of you acted inappropriately in terms of things that you should have done differently, should have done sooner, whatever the example might be. So I'm going to walk through a couple of different things. Carrie Lynn and I, we're going to give you basic overview about HIPAA stuff, all the patient privacy stuff, which all of you should take for granted now, just the way you have to do it, but just to give a refresher for everybody. We're going to talk about some of the discrimination laws that apply to us in terms of what we can do and how we want to make sure everybody's treated in an appropriate manner. And then we'll talk about some of the OSHA stuff in terms of very basic stuff that everybody just needs to think about. As Dr. Wren had said, as we go through it, feel free to interrupt us. And at the end, we're going to walk through some different hypotheticals from some things that you all probably regularly see in the office. There's also a quiz. There's like an 8 or 9 question quiz that I have here. I'm going to wait to hand it out until we get to the end, but everybody needs to put their name on it and complete the answers. It's just one easy way for us to make sure that everybody sat through and hopefully absorbed what we talked about. You're going to get graded on it if you will, but the real purpose of it is we can talk about the answers afterwards. The real purpose of it is to make sure that you just follow along with what we're going through. As Dr. Wren had said, if you don't follow something that we're talking about, just stop us as we go through it, because the likelihood is if one person has a question, somebody else is going to have a similar sort of question. So, Frank, you want to go to the next one?
Sure.
All right, so, and again, some of this is a repeat from what we did last year. The easiest way to think about HIPAA is think about the 3 bears. And this is an old thing you can see from the size of the computer. It's that someone's been eating my soup, someone's been sitting in my chair, someone's been accessing my doctor records. There's rules about things that you can do that you can't do when somebody calls you on the phone, somebody sends you an email, somebody's here in the office, they want to get different information. We're going to walk through some of those things just as a reminder for everybody about what you can and can't do. You can go to the next one, Frank. The government, since the law was passed, has been very, very fixated and focused, and you've probably seen it in the newspapers, not even like healthcare journals, but in the public newspapers, talking about there's a HIPAA issue. Somebody loses a laptop, somebody sends something unencrypted, somebody gives information away the wrong way, somebody throws paper files out into a dumpster, and some investigator goes and finds stuff in a dumpster and sees all different sort of patient information. It happens. You guys see a lot of different patients, even with automation. Sometimes that makes it harder. You see a lot of different patients on a regular basis in multiple different offices. Those of you who are in the hospital as well, lots of different types of interactions. So on this slide is some basic information about the statute. It was passed almost 20 years ago now in 1996. There's been subsequent updates to it a couple of different times, and there's been some new regulations. Basically, just as a reminder, in terms of the way the process works, when it works, Congress passes a bill. House and Senate at the federal level both agree on the bill, goes to the president signs the bill. Then you have a new law. Oftentimes in that law, it says regulatory agency or regulatory agencies help us interpret what all the congressmen and women and senators meant when they said, here's what you can and can't do. So in this case, through the Department of Health and Human Services at the federal level, they create the rules behind what the statute says. So those are all the regulations that explain the basic principles of the HIPAA rule. You can go to the next one, Frank. So under HIPAA, if somebody talks big picture about HIPAA, there's actually a number of different elements to it. There's the electronic transaction standards, the privacy standards, which is really where we're going to spend a lot of our time today. The security rule, we're going to spend some of our time with everything being automated and electronic. We're going to talk about the benefits and the precautions that need to be taken with the security stuff. Then there's the breach notification issues, which Carrie Lynn's going to talk about, as well as the enforcement. All of these statutes, if you do something wrong, there's penalties. It's largely fines or other sort of sanctions that they enter into. It applies to the office, so don't think, geez, I'm not one of the physicians, geez, I'm not one of the owners, it's not going to apply to me. It will affect everybody if there's something that goes wrong. If there's an alleged breach or somebody giving information away inappropriately, it's going to affect all of us in terms of the things that we need to do. You can jump to the next one. So what's the privacy rule? It's national standards dealing with people's protected health information. You guys probably all heard that term PHI, but it's deals with what's called protected health information for entities who are called covered entities. You can go to the next one. You start with the protected health information. You actually have to go one step before that to what's called individually identifiable health information, which is the information up on the slide here. These are all the things that, from the government's perspective, from the federal government's perspective, they can use to identify who Bruce Armin is. Okay, it's things like birth date, name, your first name, last name, social security number, Blue Cross Blue Shield card, inpatient admission date, wide variety of things. If there was a photograph of me that the office had where it could identify who I was, a wide variety of different things that they consider to be this individually identifiable information. Then you have this bigger category, health information, which is pretty much everything under the sun. You can go to the next one. You can see here also the definition for health information. If you think about it yourself when you're not working here at JUG, but you're a patient someplace else, and you interact with a provider, it's everything under the sun is what's considered health information. It's then parsed down a little bit more to be considered what's called individually identifiable health information. And then ultimately it's going to get to the protected health information. You can jump to the next one. So here's PHI. PHI, the protected health information, is the individually identifiable information, which was those, it's like 23 different criteria that the government says this is how we can identify a particular person, whether it's transmitted or maintained in any form. Electronic, paper, or some other way, and there's a couple of different exceptions to it. But pretty much all the information we have in the office, or all the information that's transmitted back and forth between the offices or the hospital or the surgery center or the stone center, all that information is going to be governed by HIPAA in terms of what can and can't be done. Go to the next one. Who's it applied to? There's a couple of different subtabs on this one. It applies to covered entities, healthcare providers that transmit information in electronic form. When we submit our claims to Medicare or Horizon, and hopefully they pay us, all that information is what triggers something being a covered entity. You can keep going. One more. So there's three basic types of entities that are considered covered entities. We at JUG are obviously considered that healthcare provider. Health plans, the Horizons of the world, they're also governed by these rules in terms of what they can and can't do. Then there's these outfits called healthcare clearinghouses, which are bodies that are actually transmitting information by and between various parties. They're also covered by it as well. Who's a healthcare provider? It's any individual or entity or organization that provides medical or other services who furnishes bills or paid for those in the normal course of business. Wordy definition, but it's what we are as a medical practice. You guys treat patients, we're paid for treating those patients. We submit claims electronically to a payer. That means that we're covered under the HIPAA rules. There's general rules. So we start with the premise again under the privacy rule. There are certain things that we can and can't do with people's protected health information, that PHI. Remember, we start with the health information, break it down to the individually identifiable health information, then the PHI is actually the stuff that we're holding, maintaining, transmitting. There's rules in terms of what we can't do. We, when I say we, I mean JUG as a covered entity, can't use or disclose that protected health information of an individual except as permitted by the rules. Okay, so if the rules don't allow it, you can't do it. It's not presumed that you can do it, it's presumed that you can't do it, because from the government's perspective, they wanted to protect all of our information and who can use it and when they can't. PHI can be disclosed for three big bucket categories. One is called treatment purposes, one is called payment purposes, and one is called healthcare operation purposes. All of these have wordier definitions, but treatment is pretty obvious. It's when JUG is treating a patient, or if JUG needs to send something back to the patient's primary care physician, or to a radiologist, or it comes from a pathologist, all the interactions with other providers, those things likely fall within the treatment exception. Also for payment purposes, we need to send something to Horizon or Medicare because they're asking something to support the claim. We send that claim over, we can send that information over. When we do these types of activities, we don't need to get the patient's permission to do so. It's presumed acceptable. If you're dealing with another provider who's the provider for treating that patient, certain things you can do. If you're sending a claim to the third-party payer, it's deemed permissible that you can send certain information. You go to the next one. Bunch of different administrative requirements in here, and these are some of the things. This is some of the nuts and bolts sort of behind the bigger policy. The office has a HIPAA policy. Danielle is the privacy officer for the company, so if there are issues that arise that you have a question or a concern about, go talk to Danielle, go talk to one of the doctors. Do not ignore it. Do not pretend it didn't happen. Do not think somebody else will take care of it. It's not my responsibility. We need to make sure that we're collectively, you can, is there a couple more on there, I think? It probably goes towards the bottom of the page. Yeah, perfect. So don't ignore it if something happens, but there's a wide variety of different issues. Danielle's our privacy person. You can also go to the physicians if Danielle's not available. Critically important, if something goes wrong, and Carrie Lynn will talk about this, if there would be what's considered a breach, there are timing issues in terms of how quickly we need to let various people know. And we've had breaches already. It happens to every medical practice, it happens to every healthcare provider, where everybody's using their best of intentions, but something goes awry or goes not quite as we had planned, and something can pop up from that. Patients also are told, that notice of privacy practice, you guys have all probably seen that when you go visit your own physician. Notice of privacy practice says, here's all the things that we as JUG, what we can and can't do, and oh, by the way, if you think something didn't happen appropriately, we have to let you know on that notice where they can go file a complaint. So they can file a complaint, they would write a letter to our privacy official if they think something went wrong, or they could contact Health and Human Services, HHS, if they had a concern that something wasn't done appropriately. There's training. This is obviously what we're doing today in terms of, on at least an annual basis, talk about issues. If you see something that you're not familiar with, don't wait till we do the training a year from now. Talk to Danielle in the interim, talk to one of the doctors in the interim, don't ignore it. Okay, because the likelihood is if one of you are confronting a situation you're not comfortable with, somebody else is going to be confronting a situation you're not comfortable with, and we just want to use it as a learning exercise in terms of how do we make sure that we're doing the right thing. We've built safeguards into our processes in terms of the things you can do, some of the things on the kiosk, in terms of making sure you have certain protections, but there's other things that we'll talk about, some of the different hypotheticals. Some of it is using good common sense judgment. Somebody calls on the phone, hi, I'm Bruce Orman's spouse, can I get Bruce Orman's information? Oh, sure, tell me where to send it to. Before you go through that exercise, you need to make sure that actually, one, Bruce Orman's a patient, two, who Bruce Orman's spouse is, three, did Bruce give permission to his spouse to access that information? Don't assume just because somebody's calling that they're a spouse that it's okay to turn over. If somebody's involved in some sort of separation battle or a custody battle or having a strained relationship, don't assume you can just turn that information over in terms of how it's going to be handled. Somebody calls on behalf of their elderly parent. Don't assume just because they say, I'm calling on behalf of my mother or father, please give me certain information. We need to make sure who they are, where they are, why they're asking for it, and our paperwork and our process in place are designed to do that. We have the ability, JUG, if somebody doesn't do something appropriately and doesn't follow the rules, there are consequences for that. I hate to bring one of those things up, but we need to make sure everybody toes the line and acts appropriately in terms of following what the rules are. It's not something that the doctors are going to cavalierly do, but at the same time we need to protect JUG, which is bigger than any one individual in terms of anybody acting inappropriately or not following the rules or ignoring what the rules are in terms of how these things can get done. And these things are outlined in the JUG policies as well in terms of things, how things can get handled. If somebody raises a question, a patient raises a question about an alleged violation of privacy, the federal law prohibits us from going after that patient and taking some sort of action against them. As angry as you might be, how dare they, they're misguided, it's unfounded what they're saying. There are protections they build in place because the government wants to make sure somebody who's alleging an issue has the right to raise that concern without fear of any retaliation happening against them for what happens. Again, various policies and procedures we have in place, Danielle has them, that walk through how we handle all different sorts of situations. You go to the next one. And the last one, documentation is the key, and we should have put this up at the top. If something happens, we need to clearly document it. Most of us can't remember what we had for breakfast today. We're not going to remember 6 months from now if there was a patient incident in terms of how we handled it and what we did. The documentation is very, very critically important. It's make sure that we do it the right way, that it's complete, it finds its way to Danielle, because one of the requirements that Carrie Lynn will talk about on the breach standards, there are reporting obligations that we have to make to the federal government, even if it never becomes a media story, it never makes to the newspapers. If there are breaches of an individual circumstance, we need to keep a log of those different things and be prepared to share that with the government, because the government wants to know what's going on out in the world in terms of how things are happening. So if something happens, make sure it's clearly documented so we know who we interacted with, what sort of authorization, if we got one, whether a document was signed by a patient, just so we make sure that we're protecting ourselves in terms of what's getting done. So the first thing there's a couple of subsets on this. So the first thing that we talked about was the privacy rule under HIPAA. The other rule that we're going to spend a couple of minutes talking about today is what's called the security rule. The security rule deals with, you can go to a couple more, Frank. I think there's a couple more subsets on it. There'll be one more. Perfect. Under the security rule, which is the electronic transmission of that PHI, there's systems that the company has put in place with Todd's help and with the doctor's help and Danielle's help to make sure that we know how things are being done and how it's being done. So there's 3 big picture sets of rules. We could spend an hour talking about these, then no matter how many donuts you have, your eyes would glaze over. So I'm going to go through them pretty quickly in terms of talking about it. But just focus on it so you understand there are systems built into place for what we need to do. There's what they call administrative safeguards. Okay, that we as a company, as a covered entity, when we're doing things, we have to do things a certain way. What the government has done, they've created what they call these required implementation specifications and these addressable implementation specifications. The required standards are mandatory. This is what we have to do. The addressable standards, the government at least had the foresight to recognize that it's not one size fits all. JUG is not like every other medical practice. In many respects, JUG is different from many other medical practices in terms of the things that you are looking to do with technology and the way you get patients in and out and the type of care that you're providing. But they built in these flexibilities so that the practice, JUG, has the ability to figure out, okay, for certain administrative standards, we're going to do our own internal benchmarking, we're going to do our own internal analysis, and figure out what the best way to do things are. Similarly, there's physical safeguards. When do the computers log off? If you walk away from your desk, at what point will they log off? So a patient can't be walking by and see information about another patient when they're going to see things. Again, there's required standards and addressable standards that they've built in. Finally, the last big bucket under the security rule are some of the technical standards in terms of what the software has to be able to do, how it can work, whether or not to use encryption. And again, there are required specifications and addressable ones. These things have all been done already, but they're constantly being refined. So if you see an issue that you say, you know what, I wonder why we're doing something this way, or perhaps we can do something better, or maybe we could do it a little differently or more efficiently, let Danielle know, let one of the doctors know, so we can make sure that we're staying ahead of the technology in terms of how things are changing and making sure we're protecting all that patient information. Go to the next one. So Carolyn and I will talk about some of the breach issues, and then we'll jump back into some of the other stuff.
So Bruce was telling you about the privacy rule and all the things that the government set in place to make sure that PHI, protected health information, is kept safe and private at all times. And like Bruce said, HIPAA was actually passed as a law something like 20 years ago, and it kind of lay dormant for a while. And, you know, practices and hospitals did their little bit of privacy standards, and then, but it didn't have a whole lot of teeth to it. A couple years back, the government passed some legislation that now added what are called these breach rules that required covered entities like medical practices to do certain things when you don't abide by those privacy rules. And so what the HIPAA law now says is that covered entities are required to report breaches of unsecured PHI, and they have to report it to possibly up to 3 people. The individuals involved, the Secretary of the Health and Human Services of the United States, and potentially the media. We'll go to the next one. We'll get into these each a little bit. So the first step is when a violation or something happens is we've got to figure out, is this actually a breach? And a breach is basically anything that happens with PHI in a manner that's not permitted by those HIPAA rules that Bruce was just telling you. How you've got, what HIPAA says is that you must do, you can only use or disclose your PHI in accordance with those rules. Well, breach is sort of the opposite in terms of, okay, you didn't do this in accordance with the rules. That actually compromises the security or privacy of PHI. And there's a couple exclusions that the government built in of circumstances that they know can come up, and have deemed that although this isn't, technically correct under HIPAA, we know that there's probably a low risk of anything really going wrong. So one of these are when you in good faith, somebody within the same workforce discloses it to somebody else within your own workforce, and it doesn't lead to that information getting out further. That's an example that the government has said, okay, that's not technically correct under HIPAA, because even under HIPAA, within our own internal organization, only certain people can access PHI for certain reasons, but we think that this would be one that probably is not going to cause a patient harm. Another one, similarly, is where one authorized person who actually can view that PHI is given it perhaps at a wrong time, but they are actually authorized to view it. Government says that's okay. And certain other disclosures where somebody couldn't possibly have retained the information. So the key to know is when you see something happen that you know isn't quite right or you think it might not have been done quite correctly, let Danielle know. And then from there, she can get the process rolling to figure out, was this actually a breach, because did it actually compromise the security of the PHI? But the point is, when you see something that you think might not be quite right, make sure you go there and she'll get the ball rolling. Frank, the next one. So we talked about that breaches actually apply to unsecured PHI. And PHI that's unsecured is that which is not rendered unusable, unreadable, or indecipherable to unauthorized persons. So for instance, the government has said if there is encrypted information out there that nobody could ever potentially read, even if they were the wrong person, that's not necessarily going to be a breach. So there's certain things that the government has said where nobody could ever actually read this PHI, that's going to be not a breach. But anything that is on a piece of paper like this, emails that get hacked that aren't encrypted, the laptop that's left out that's not encrypted, all of that would be unsecured PHI. Frank. So, Bruce started to tell you that there's certain things that you have to do now when there is a breach, and covered entities must do. And so that's why it's important that you do notify Danielle or one of the doctors if you notice a situation, because there's certain things that Jersey Urology under the law has to do. The first thing is, if there is a breach, the people who are involved, the actual individuals whose information was accessed, they must be told. And what you have to do is, and it has to be told within 60 days. So they have to get a letter that tells them certain information, like when it happened, what Jersey Urology has done to fix the situation, potentially credit reporting for them if that's an applicable remedy. So there's a letter that actually has to go out to each person. Secondly, in one way or the other, the Secretary of the U.S. Department of Health and Human Services always has to be told. When it's a really big breach, meaning 500 individuals or more's information got out there, which fortunately we've never had here at Jersey Urology, that would have to be reported to the health and the federal government at the same time that you're notifying the individual, which is in the 60 days of this happening. For ones that are less than 500, Danielle or whoever, we have to maintain a log every year, and at the end of the calendar year, within 60 days, you've got to report everything that occurred within the prior year that was less than a 500-person breach. And finally, again, for those really big breaches, there are more than 500 people, you have to notify the media in those situations. And again, fortunately, we have not had that situation occur here. Okay, next one. So again, Jersey Urology does have a breach response policy. Danielle has that. You need to know to report those situations, and then she gets the ball rolling with those other steps and figuring out, was it a breach? Who do we need to notify? When do we need to notify them? And all those other things. So you being here is important, and you certainly have access to the policies to read them to make sure you know what to do. Right. Next one. The other portion of this that's important of not only when you have these breaches or you might be doing something wrong, back when the government amended the HIPAA law to tell people we're going to add these breach note requirements, they also stepped up the penalties in HIPAA, and that has also given HIPAA a little bit more teeth. And there's different categories, and depending on how the situation occurs or how the breach of HIPAA occurs, they can, as you see, range anywhere from $100 per violation up to $350,000 per violation, depending on how it occurs. The point is to know that this is real stuff. There are real potential consequences, so we got to make sure that we do things right and appropriately.
And if I could jump in for one thing, I mean, you've probably seen in the newspapers there are large health systems where somebody might have lost a laptop, and they enter into fines of several $1,000,000 that they agree to pay the government. So it's real money, because the government not only wants to get some sort of economic recovery for what may have happened in that particular circumstance, but also give a warning to every other covered entity that they need to be aware of these things. That if you don't act appropriately or act with all the safeguards that you need to, there are real ramifications for those things that can happen. So if you pay attention, you'll see things in the newspaper where somebody might agree to a settlement without admitting wrongdoing. That's basically because they entered into some negotiated agreement with HHS for some type of breach that they had, and try and figure out how it's easier for the company, no matter how large or small, let's make this go away and agree to some sort of settlement agreement with the government so they can try and move on with their practice.
All right. So again, I think summing up of where we are with HIPAA and what the point is today. At all times, remember how critical and how sensitive patients' health information is. Err on the side of caution and do everything you can to protect that, because as we talked about today, there's certain things that happen if that information is left unprotected. Jersey Urology does in fact have all sorts of HIPAA policies. It has a breach response policy. Know them and understand what you have to do. And if you ever have a question about the privacy or what the next step is, or you get a weird request you don't know what to do about, go see Danielle, go talk to one of the doctors if she's not available. And again, we've said it a couple times now, but if you suspect that something was done inappropriately, that, hey, you handed out a report that went to the wrong patient and had something on, you saw something else occur, make sure that you tell somebody, because it gets worse if you don't do it. If Jersey Urology then doesn't comply with the law, doesn't do those notices in the time it's supposed to because you didn't tell anybody, it just all steamrolls and it gets way worse.
So, maybe before we hop into that, are there questions about the HIPAA stuff at all? Because we're going to totally switch gears and walk into a different subject. Everybody feel like they have a good handle of that stuff? Know what to do? There are a couple of quiz questions about HIPAA, I promise, that we threw on there as well. All right, we're going to jump to the next one then.
All right, so we want to talk a little bit, switching gears, about the New Jersey law against discrimination. And part of why we want to talk about this particular law, Jersey Urology puts an emphasis, and they want to make sure all of the employees here are comfortable, everybody's respectful of one another, no matter what your position is, and making sure that you understand the things that they're doing to try and make sure that occurs, and make sure you know what to do to make sure your coworkers are all comfortable and feel fair. The New Jersey law against discrimination, just briefly, is a state-level law that protects workers against discrimination in the workplace. So you might have heard, you probably have heard of, at the federal level, there being anti-discrimination laws. Well, you have to be an employer of a certain size for them to apply. But certainly the New Jersey law against discrimination applies even where somebody might not be covered by the federal law. And in New Jersey, it applies to all employers, unless you're a federal agency, regardless of the size. So it does apply here at Jersey Urology. Next one. Okay. So we have a slide here, and I'm not going to read each of them off to you, but there's what are called protected classes of people that the New Jersey law against discrimination protects. You can't be discriminated against because of your age, because of your race, your nationality, because of your particular sex, including if you are a pregnant person, if you're disabled in any way. So there's a number of categories here, but just knowing that you can't treat people differently or inappropriately because they happen to fit in one of these classes. All right. And here's what the teeth of the law and what it says you can't do. Is your employer can't refuse to hire, employ, or discharge or otherwise discriminate against an individual because they're in one of these categories. They can't treat a person who's disabled differently than somebody else. And it does protect employees of the practice. All right, next one. So again, one of the things, one of the categories we just talked about are disabilities and not treating people differently because they're disabled. And the key point of this slide is that that means not only somebody who's physically disabled, for instance, they happen, they don't have an arm or something that's physically apparent, but it also protects mental impairments and mental conditions. And so what the law says is that an employer has to provide a reasonable accommodation to allow you to do the basic duties of your job if you have a disability. And the point is, Jersey Urology wants to be able to work with people if you do have something that is a disability, to let them know what accommodation you might need if you do need one, and not keep that a secret and potentially have that disciplinary issues because nobody understands that you have a special situation because of a disability that's not allowing you to do your job. But if you had just a slight tweak, if you needed to have your computer positioned differently or something like that, that would help fix that for you, that is what you need to present. Jersey Urology will work and come up with what is a reasonable accommodation. That does not mean that Jersey Urology has to buy you a $6 million machine or something like that that would allow you to see something differently. It is a reasonable accommodation, and there are things what are called undue hardships for the employer, that they don't have to do everything, but if it's reasonable, that would be a process to go through. One thing that's important to Jersey Urology is that there's not sexual harassment in the workplace, and that's something that's also protected by the law. And what it means is there should not be any sexual advances, there shouldn't be requests for sexual favors, and there shouldn't be, and this is the tricky one that a lot of people fall in the trap of, is physical conduct of a sexual nature. And that can easily occur. People make jokes all the time. You see something in the news, you watch something on the internet, and you bring it up, or you come in and make an inappropriate, or you don't think it's inappropriate necessarily, but you make a joke about it. Those are things that you've got to be sensitive to in the workplace. That although you might find it funny, you might find it amusing, you think every other person would feel that way, not every person does. So you have to be careful of what you say to people, particularly if it's anything of a sexual nature. That is something that we can't have in the workplace. Retaliation. The point of this is that we want you to know that you should feel comfortable if there's to come to one of the doctors, if something occurs in the workplace that you are not comfortable with, one of these sexual situations we're talking about, feeling that you are being treated differently because of some sort of protected class. What the law says is that if you come to your employer and say, hey, this issue occurred, and I think it might be a problem, they're not going to go against you or do anything to you because you've presented that report. You should feel safe. If you think that there's an issue or anything going on here, the doctors have made a priority. They want to make sure it gets taken care of. You should feel comfortable to go there. It is protected under the law. Okay, so coming to the end of this portion of our training today, make sure you understand the basics of the New Jersey law against discrimination. Treat your coworkers with respect. Don't treat people differently because of some sort of characteristic. Be mindful of what you say to your coworkers, any of the sexual stuff. Make sure you understand JUG's policies and what they want you to do. And again, if there is an issue, if you think something has occurred, if somebody is making you uncomfortable, do talk to somebody, bring it forward. Nobody wants that going on in the workplace. All right, before we go to OSHA, are there any questions about the law against discrimination, the New Jersey law?
I just want to reinforce what you said. Come to us if you have a question, issue, problem, concern, complaint, anything. If you don't feel, if you want to speak to one of the, Melody or Danielle or Jessica or one of the physicians, please come and tell us. Because the last thing we want is in a place where you don't feel comfortable coming to work. So you need to please just, whatever it is, let us know. And it may be, as you said, it may be something somebody thought was totally innocuous, but that's one perspective. Your perspective may be it's not an innocuous statement.
Absolutely.
And they need to be educated, if nothing else.
Yep.
I have a question about reasonable accommodations.
Okay.
Let's say I'm a baseball pitcher and I break my arm, and I pitch for the Phillies. While I might be a better pitcher than most of the Phillies, what accommodations would the Phillies have to make for me at that point?
Well, the situation of breaking your arm is also a little bit tricky because when something is just a temporary condition, it may or may not be a disability. But assuming you had some sort of arm issue. If you're never going to be able to pitch again, no matter what happens, probably not an accommodation that can be made. If you need ice every day after the game to make sure that it cools down, that would probably be something that would be reasonable to ask for. And the reasonableness, just because you do use an organization like the Phillies, who they're paying these pitchers $26 million a year and clearly have money to throw around on people who aren't very good.
You can tell she's a baseball fan.
The same standards that would apply to the Phillies, and for the moment we're going to pretend that the Phillies are in New Jersey under the New Jersey law against discrimination, but the same standards that apply to a mega organization like the Phillies are not the same standards that would apply to a small 5-person business. And so the reasonableness standard will vary and depend upon your particular business. That's where I tried to use the extreme example of somebody needing a $6 million machine or something like that, or asking for one. But the reasonableness will depend on the particular situation.
Questions about that stuff at all? All right, so why don't we hop into some of the OSHA stuff, and again, as Dr. Schutz had raised, the important thing is don't let these things snowball. If there's an issue, let's raise it and address it. Yeah?
Let's go back to HIPAA.
How would it stand with the kiosk if, one patient's checking in and the other patient's standing right over them, able to view their information?
Absolutely, I think this is the
Aren't they
truth.
supposed
You
to
can't
stand so
stand
many
here talking
people
about
behind?
HIPAA and have.
In the ideal world, and we can talk about it because the kiosk is a relatively new phenomenon in the office, making sure that there's some tape line or something where somebody's a little bit back so they're not hovering
They're
on top.
right
And
next to each
yeah.
other, they need to have
a screen.
sections, they need to be spread out.
Can you see it if you're standing at one?
Yeah.
Yes,
level?
you can. And they look at each other's stuff as everybody
And there's
checks
5
in.
people in one person's
think
picture.
We have patients helping other patients as well.
Try to compete. Well, I mean,
I mean, they have walked in the door
There's a
and
couple
HIPAA
different-
has gone right out.
we can certainly do some things with the kiosks in terms of making it more user-friendly for the individual and keeping their privacy. Now, if somebody voluntarily on their own says, hey, you, neighbor, using this other kiosk, can you help me fill that out? That's entirely their prerogative in terms of doing something. One of the takeaways from that privacy rule is an individual controls their own information. So if an individual says, please come help me, they've sort of voluntarily given up that right to the expectation of
But you
privacy.
can't stand at any one of these and control your privacy.
Right.
No patient has since they've been installed.
We can talk with the doctors about how we can best shift these around so that it's functional for the office and at the same time, maybe even just a little screen. So somebody would have to consciously try and look around if they wanted to see something. If you're at the ATM,
Or those screen
they're a bank of
protectors-
4
those screen
ATMs.
protectors that go on computer screens, that you can't see it at anything except direct on it.
They're
Yeah.
blackout from the side.
But they're,
You have to either be
they're
looking
taking
over
their
or right.
pictures with other people in the picture. It goes into their chart with multiple people.
Do you guys
on a
phase
picture.
that out or blot that out?
No, and they also can't take another picture to replace it.
But the only people who have access to that picture is us.
It's still only you, right? I mean, so it's still, I mean, in the ideal world, yes. And we'll talk to the doctors about what we can reasonably do in terms of, having that expectation of privacy.
Can we get a privacy screen protector for the screens?
You mean, so like, how
Like
would,
they have for the phones, where you can't see it if you're on the side?
Oh,
the sense I had is that people could stand behind you and still see it,
And that's what
not from this side. So here's what I'd suggest. We will talk to the doctors about trying to find some practical ways that we can address the situation so patients are comfortable with the intake process, they can complete all their information, and if they want to voluntarily ask somebody who also happens to be in here to help them complete something, we can do that and try and find the most effective way that these things can still work but maintain people's privacy. Have you guys had any patients say, how come so-and-so can see my information? Yes,
Or
okay.
how come this person is standing like directly behind me while I'm checking?
Or
Have-
right next to them. I mean,
Yeah.
there is not a foot between people.
Have you let Danielle know about it? Okay, all right, so we'll work on putting a solution together. I mean, and it's these sort of things that we want to make sure, and it's great that people are being proactive in identifying it, so we'll work on coming up with an appropriate solution. Because the kiosks aren't going to go away, but we need to figure out a way to make it work.
And my other question is, we constantly have them updating their HIPAAs, who we can talk to about their information. If for the previous 6 HIPAAs, their wife was on it, but the last one they forgot to put her on, we've been instructed that we can't talk to the wife.
I would use whatever the most current version of the form.
Even if the one previous is 6 weeks before.
People might change their mind. Somebody might have gotten into a divorce process with their spouse.
Can we forward those irate spouses to you for discussion? Because
Yeah, I mean,
it's really,
and maybe.
it gets to the point
And maybe
where-
part of the reminder is and we're gonna talk to Dr. Wren about part of the intake process and making sure, if you're seeing these types of issues, you obviously wanna be patient friendly, which is obviously why you're raising this as a concern, because you wanna do what's right for the patient. We need to be cognizant about what the federal law is, so if you're seeing those examples like that, like somebody overwrites a form that they previously filled out, maybe the follow-up question is, do you realize on this last time that you filled this out, you gave permission to so-and-so, you've now taken that away? Is something going on in your family circumstance? Because it happens.
Right, but here's, by the time they can't read all these forms. All the forms are
Why
on here,
can't they?
they're constantly asking.
It's too glary and they're too loud.
Right, by the time they get
It's not that they
all,
can't.
everything signed, they have no idea what they have signed, what they have filled
I have
out.
no idea.
They have no clue.
They just sign it.
I think
Just
Dr.
real
Piskin has
quick, is there some leeway within the law for verbal consent? For example, Mrs. Smith calls, Mr. Smith had Mrs. Smith on the consent 6 times, 7th time Mr. Smith forgets to put him on. 7th time Mrs. Smith calls, can Mr. Smith come on the phone and say, I'm Mr. Smith, this is my information, I forgot to fill out my wife's one. Can we take verbal consent for that episode, or does it have to be written paper consent in the computer?
I'm generally not comfortable with a verbal consent if there's not a way to record it and transmit it back to writing, because people's memories change. And,
All our calls are recorded.
well, if the call's recorded and you say, listen, the call is being recorded, and then we transcribe it and put in the record that on October 16th, Mrs. Smith called and gave the permission to Mr. Smith to access the information, that gives you more protection. In the ideal world, we have it in writing all the time. And maybe there's a tickler for the next time Mr. Smith comes in to make sure that Mrs. Smith is on that process and approves it accordingly.
Right, I think what we're looking at is that one episode where you're trying to satisfy, that it was an honest mistake on the part of the patient. Can we, accept verbal consent if, you can verify it's the patient?
Yeah, I mean, if you have a way to know who was on the phone is the spouse, and it's not somebody trying to pull a fast one.
Yeah, like how do you tell?
Well, I mean,
What's the right questions
there
to
might be
ask?
information in the patient's file. Can you confirm your home address? Can you confirm your home phone number? Can you confirm your spouse's date
Is
of birth?
Social Security too far to ask that? Or
Some
is
people
it-
might know their spouse's social security number, some people might not, but if you start asking questions and they're like, oh, I don't know my home address, why are you asking me that question? Or why are you asking me my home phone
Well, I
number?
think you
Or,
would
you
want
know,
to get the actual
The patient.
patient to give that consent, not the.
Yeah,
not
the
Yeah, if you get the
Yeah,
patient
but-
online.
Given the,
Could they each have a secret word?
given the sensitive, guys, given the sensitive nature of issues we take care of for these patients, we need to make sure that every T is crossed and I is dotted. We have patients who come to us with very private concerns, whether it be about their urinary system, which is general health, but also their sexual system, and they may not want their spouse to know that. So if the form changes, we have to assume, I think, unless we know for sure the patient really wants that to be. It's
Yes.
unfortunate, but it's the nature of our specialty.
we don't want to get caught into a gotcha situation.
Well,
Or get involved in somebody's separation dispute about finding out that somebody has an issue. Yeah.
things that have happened, I've had patients on the phone, they put it on speakerphone, so I have both husband and wife on the phone.
Presumably.
Or the husband who doesn't want to deal with it hands the phone to the wife. Now, she was on the old HIPAA, but not on the new HIPAA. But now I have both of them on the phone. So
I would
she's
encourage
picking
them
up the other
if they have a concern to make sure to come into the office, because again, you don't know who the other person is on the phone. You might think it's the spouse, you might recognize the spouse's voice, but you have no idea the person can be saying, you better, like nodding, pointing fingers at them, you better just say it's okay or whatnot.
Well, that's what I mean, or somebody, instead of picking up the other phone, now I've got two of them talking.
If there's a doubt, I would encourage them to come to one of the offices and you can address it in the office in terms of how best to handle it. Yeah.
In a specific case, like for example, if what Dr. Wren said, if say a man has a concern about his sexual health, but he has power of attorney on file with us, that power of attorney gives his wife the ability to know his information. but he does not want that information on his sexual health released to his wife, that power of attorney doesn't, we can't release the information to her, even though if his mental efficacy was somehow damaged in the process of him being like in and out of our office, we could release information to her, but at that time, if he decides that he doesn't want that information released to his wife.
The new HIPAA addresses that.
Yeah, but if there's some HIPAA form on file,
But
which
if they
is what we've run into.
What all type of power of attorney? I mean,
You're talking about the HIPAA form they used or an actual
An
power of attorney written by a lawyer?
Yeah.
There wasn't a HIPAA form on file, but there was a power of attorney form on file. So
and
when
the
she
power of
called
attorney
in-
said, I can turn over all of my information to my spouse, and my spouse is entitled to all that
In
information?
our case, it was the daughter, but yes.
If you see a situation like that, I would say let Danielle know or one of the doctors so they can reach out to me. Because it's hard to give me advice on a specific circumstance without knowing exactly what the document says, because I don't want you to take my word and say, great, somebody gives me a power of attorney, boom, I can run with it. They can have very different parameters in terms of what they talk about or what they don't talk about.
Most of the power of attorneys that we do come across are patients that can't make their own decision normally.
Mhm.
In this case, this patient could make their own decisions and can speak, and it just so happened that his daughter happened to be the power of attorney. So the concern is that if it had anything to do with maybe a vasectomy or what have you, maybe his daughter shouldn't know that.
And the person never filled out one of the authorizations to say I'm giving my spouse or daughter
No,
or?
they just faxed in their power of attorney, that was the only thing that was in the chart. How they got past the HIPAA?
Yeah, that's what I'm wondering how they got through the, well, I'll tell you what, let me think about that, because I don't know the answer off the top of my head in terms of how to juggle those things.
Whatever you need for that patient, but it was, all around, it was just a little odd.
Okay.
And we have been treating power of attorneys as their care provider.
Do you have a copy of the power of attorney so you know what it says? I mean, because some powers of attorney
Yeah,
might
it's
be
in the
very
chart.
specific
It
about
was in
records,
the
some might
chart.
just.
Let's,
I'll tell you what, how
why
about
don't you
we
forward the
talk
information to
separately
Bruce so
about
we can
that,
get it
Danielle?
offline?
Yes, we can talk separately about that. Are there any other questions about this stuff? And it's great you guys are raising questions about, because this is the stuff that, it's hard for me sitting in my office to appreciate the things that you have to deal with on a regular basis and make sure that we're doing the right thing. So if you have those other types of questions, what I would say is get them to Danielle, and then Danielle and I can talk about it, and we can walk through various scenarios, and then she can almost give you guys a guidance sheet, if you will, in terms of how to handle situations. But when you're confronted with these things, don't just make the judgment on your own. If you're not sure, go to Danielle. Danielle can decide what's appropriate and or talk to the doctors or reach out to us if there's a question. But just don't say, oh, for this one-off, I'll do something, because that one-off is the sort of thing that can get you adverse consequences.
So just to keep it clear, Dr. Ren kibosh that you could have a patient and his wife on the phone and tell them that this call is being recorded and we can make this exception once because your HIPAA from 6 weeks ago has been usurped by your HIPAA from 3 days ago where you
Yeah,
forgot to put
I
your
guess part of the question is why somebody's filling out a new authorization, if you will, each subsequent time. If that, I mean,
We had 4 at least in the last year on OTAP. They are constantly
They're
being
updating them, Bruce.
updated.
We have a new HIPAA form is the bottom line. It's a one-time thing that everyone's going to have to fill out the next time they come to the office.
Okay.
It's much easier to read, it's much easier for the patient to understand. Everything is typed out at the kiosk. Patients do it at the kiosk so they have privacy at the kiosk and they can select who they want to receive their information at the kiosk. And it's a one-time new thing and it should not be an issue in the future.
okay,
I have
yeah,
a
so,
question about the new HIPAA form.
yes.
Now, if a patient comes in and say they put their daughter on the new HIPAA form, they're on the kiosk now, then they come in their next visit and they want to add somebody else, how are they gonna add somebody else onto it? Because once they fill it out,
They
it
will
doesn't
need to
come back
fill out
to
a new
the
form.
We're handing it to them.
They will ask, I want to add someone to my HIPAA documentation and you will get them a new form.
Isn't that one of the
Even
questions
if
on the
you-
kiosk? It says, is there anybody else you want to add? Isn't that like one of the follow-up questions?
No, only the first time that you fill out
Yeah.
the form. If you don't put them on that form, then the patients will need to ask for a form, either at the front desk or billing or.
So do we give them the old
No,
HIPAA
you
form?
print out the new one was sent in an email.
Everyone,
So how do you fix that?
top, one person at a time. Dr. Lehrfeld is the issue, make sure the kiosk gives them that question to ask.
Okay, I got an issue.
Yes.
Today we had an issue with a nursing homes. She came without her granddaughter. We have all these new pages, we had to give them all the new pages, ABN, everything has to be signed. She wanted to sign them, but her aide didn't want her to sign them because the daughter wasn't there. So what do you do at that point.
And the daughter had the,
She wasn't there. The granddaughter is her power of attorney, and she wasn't there.
You have to reschedule.
Real-
What else
yes, you
could
have to be,
do?
I mean, because
Well,
it's
that's
not
what we
the
wanted to
aides.
do to her, and she said that she could fill out all her own paperwork.
Then I would have documentation saying on October 16th or whatever it is, this individual affirmatively said they can complete all the paperwork on their own. They did it without their
And I gave her
granddaughter,
all
whoever
the,
the person being
copies of
present.
it.
But the aide should have nothing to do with that, because unless the aide has any power, just consider the aide to be a driver or a physical helper to get somebody in and
They
out.
sign for people all the time from the skilled nursing facilities. They walk up to
Especially the
OTEC,
ones that are
they
handicapped.
check the patient in. they-
I'll tell you what, I would call the nursing home and say, your aides are doing this, do they have the authority to do this? Because if I was a patient,
They
I
take
wouldn't
their
want
own
somebody else to
picture
sign
for the
something.
patient.
Yeah, well, but I'm saying I would reach out to the nurse, if there's one particular nursing home where you're seeing this be a problem, I'd reach out to the nursing home manager and say, listen, we have policies here in place. We can't have aides who don't have any authority doing things, because if it's contrary to the patient wishes, we can't be held responsible for that. And, don't make the nursing home patient feel bad about it, because if they have mental issues or they're unable to think cognitively, the aide should not be putting the nursing home patient in that position, or more importantly, putting us in that position, because we're just trying to see a patient, and, if you know somebody's coming from a nursing home, it's an added burden, but maybe you reach out to the nursing home the day before and say, Bruce is coming out, let's make sure that, here's the forms that Bruce is gonna have to complete, who's gonna be there to do it, because it can't be the aide. And if it's not an emergency appointment, we need to do the right thing.
Actually, could we not have that as a policy? We just give the nursing home a bunch of the forms, say, when patient comes in, these need to be brought in, filled out already.
Yeah,
So
if
you don't even spend your time in the office with,
Yeah.
like what you get stuck with doing, you give it to, I'm sure we could reach out to the nursing home, because it probably make their lives a whole lot easier.
Yeah, and I would
They don't
just-
have to have this.
I would just make sure it's a blank form, so we don't inadvertently give people's information that gets to the wrong place, but say, here's our forms that need to be completed, have the individual or the aide who's bringing the person in, have that person bring the information in completed when they present for the appointment.
I think that's a great idea.
So then they would be checked in manually, they wouldn't check in on the kiosk.
Right.
But they
Most
wouldn't
of them
have
check
to
in
fill out all
manually
that
anyway.
stuff, especially new
The-
patients.
The specifics of the policy and procedure will send you out a clarification. Danielle, you wanna make sure you put that in the to-do list?
Other questions at all? No? All right, perfect. I appreciate you raising, and we can certainly talk about them some more. So why don't we jump to the next one, Dr. Wren, and we can go through just a couple of the quick OSHA stuff. So even though Ebola's been in the news, and now CDC and OSHA are very concerned about things, these things they've been rules in place for a long, long time in terms of basic things that every medical practice has to do in terms of making sure that the workplace is safe for the patients, and as importantly for each of you, in terms of making sure all the appropriate precautions are being done and things are being handled in the right way. The OSHA stuff is critically important. The last thing any of us want is to get some sort of infection or get some bloodborne illness because of the types of things that some of you are handling on a regular basis from the patients. We have got to be really careful with this stuff, and OSHA is there to protect you all, and obviously Jersey Urology Group is following those rules. So Frank, you can go to the next one. Most frequently one regard bloodborne pathogen. Obviously, they're very concerned about HIV and Hep B and where the consequences are. So you all should know the protections, the protocols that you're in place when you're handling or interfacing with a patient's blood, urine, semen, any of those types of fluids. Make sure you understand and you use proper technique and proper protocol. Things that are disposable means you use them once and you toss them, and making sure that you're doing things the right way. There's no tolerance for not following those type of rules. Did you have a question?
No.
Oh, you were just handing something back, okay. Just in terms of understanding how those things have to get done. You can go to the next one. A variety of different requirements that are in place. We want to obviously minimize exposure. We want to make sure that all the devices that were used are safe and clean and scrubbed, and not carrying infection when it goes from one patient to the next, or any other type of sample on it. You guys, your input, just like we talked about the HIPAA stuff, if you see something going on in the office that you think we could do better, let one of the doctors know about it. The doctors are running, as you know, crazy back and forth between the patients. You guys prep everybody, you get them all ready so the doctor can come right in and do what he or she needs to do. If you see something that can be done better, can be done differently, let somebody know about it. Don't unilaterally do something on your own and not tell anybody about it. We have processes in place to make sure that things are done the right way. There's all sorts of disposal processes obviously as well. Hazardous waste versus non-hazardous waste. There are contracts that Jug has with companies to take that stuff. So be very careful about what you put into what can and how it's being used. You can go to the next one. These are all fairly straightforward things. Anybody who's been in a medical practice for more than a day is going to understand these things, but wear the proper clothing, the proper safeguards in terms of when you're dealing with patient matter. Be careful how you're handling things. Don't mix up two patients' stuff as you're going around. Make sure things are clearly labeled. Make sure you keep things in a sanitary condition as you're working with. Make sure things are ID'd appropriately in terms of what's getting done. You guys are all working very hard, getting 35, 40 patients in here for each doctor on a daily basis. We just need to make sure that we're staying accountable and taking that extra breath and that extra precaution to make sure that you're doing things right for the patients and, more importantly, or as importantly, protecting each of you with the things that you're dealing with. Training is very important. If folks have questions about this stuff, let one of the doctors know the best way to do that. We don't want anybody to get hurt. Not when you're doing your job and you're trying to do the right thing. We don't want any adverse consequences for you, and then you take it home to your spouse, kids, friends, whomever it might be. We want to make sure everybody stays safe. You go to the next one.
If I could just hop in with one thing that was on that slide, was the observing universal precautions. And what OSHA says is you have to treat every specimen, every bit of blood that you come in contact with as though it's potentially contaminated. So just because you know, oh, I've worked with this patient for a long time, they're fine, you treat everything as though it's potentially contaminated. You follow the same processes and procedures each time.
There's other OSHA things besides the bloodborne pathogen in terms of things how to get handled. Again, there are policies in place for all of these things. Just know they're out there. Know how things will be handled. Obviously, if you need to get a patient out of the office in the case of an emergency, making sure where the quickest way to get people out of the office is to do that. You go to the next one. Basic things everybody has to do. This is similar to what we talked about for HIPAA, similar to what we talked about for the law against discrimination. There are policies in place. Follow them. Don't let something fester or snowball. Don't act on your own without thinking about the broader picture in terms of what's going on in the medical practice. Be aware of the rules. Ask questions as you go through it. You go to the next one. Why don't we do this? Let me hand out this quiz, and while we're handing out the quiz, why don't we walk through some of the different HIPAAs?
And let me just reiterate something here. If you have questions, please do not let it wait till next October. Please submit the question as soon as you think about it. If Danielle or one of the docs can't answer you or give you a rationale or say, wow, that's a really good thought, they'll kick it up. Bruce being up. And we get back to you. I mean, please don't let it wait. All right, some of the questions or observations people made today. Okay, why don't we know about those sooner? Let's get them in, let's get them reviewed. It's hard to answer things in real time. We can go and say, all right, if you're noticing a problem or you have a concern or you have a general why do we do that, just like I said, please do not be afraid to submit it up.
So the quizzes are going out now. Please print your name on it. You can sign your name. It's like 8 questions. Take a moment to fill it out from the things that we talked about. It's really important for us from a compliance standpoint. You guys are all very attentive. Just take 5 minutes, 10 minutes, and answer the questions on the quiz. Pens. Answer the questions, then you can hand them back up to the front. We can go through the questions as well with you if you want.
Anybody else need a pen?
Any quiz?
I can take a verbal. Anybody else?
Pen? Anybody else need a pen? Pass this one. Hey, Dr. Soderall? Computers coming in.
What's that?
That's my computer.
I don't know. Whose computer? You want to know whose computer? What's their baby? Really?
That's the one, right? Can I smell
So I could go over the question.
I want to see things.
There are more donuts up here. People need more sugar to think clearly.
Home offer 285.
Can I hold yours? I don't.
I get the dead chicken.
Everybody almost done?
Do you have the?
What's that? Yes. Yeah, absolutely. Well, you don't have. Has everybody finished the quiz? I'll tell you what, if everybody could just hold on for one quick second. What's that?
Who's not finished with the
Is everybody
quiz?
done?
Guys.
Shh. We'll give everybody 2 minutes to finish it, and then we'll walk through some of the answers for everybody. Because again, it's part of the learning exercise for all of us.
Oh, yeah, yeah.
Everybody good? All right, perfect. All right, hold on to your thing, and we'll collect it at the end. All right. First question. Primary focus of the privacy rule is, who knows the answer? B. Protected health information. Second question, is a covered entity jug? Just raise your hand. D? Okay, D is the answer. Third one, covered entity like jug may not use or disclose PHI except as permitted by HIPAA. True, okay. Number 4, protected health information can be disclosed for?
D. All the above. D.
D, all the above. D is the correct answer. Number 5, a breach of PHI must be reported to?
Privacy officer.
The answer is A. In terms of who has to go to, in terms of who it must be reported to is the individual. Okay? It only goes to the press if it's above a certain size. Over 500 in terms of that. No one is not the right answer. That answer C, it has to go to the individual. We put the New Jersey Department of Health. State has no concern about that. There's a federal law in terms of the federal government caring about it. So if there's a breach, it has to go, we have to let the individual know. Depending upon the severity of it, it might go to other people as well. Number 6, on page 2, the law against discrimination prohibits discrimination based on? All the above, correct. 7, the most frequently requested and referenced OSHA standard for medical practices is? C, correct. The bloodborne issues. Finally, the last question for Dr. Schutz to get 100%. Exercising universal precautions means that all human blood and body fluids should be treated as if known to be infectious. Perfect. Everybody can hand it. If everybody just make sure your name's on it, bring it up to the front.
Well, actually, hang on to them. Danielle, come around.
Yeah.
And collect.
So why don't we walk through some hypos?
Guys, we're gonna do some hypothetical situations. In medical school, one of the best ways we did learning was once we had the educational lecture, we would then present patient situations. Guys, we would do patient situations to try to put it in real life and see what do I do in that situation. So there'll be some questions here we have for the docs, some we have for the staff. We've got our 2 judges right here to see how well the answer is. Number one, this is there'll be a staff and a doctor question. Dr. Gove, not listed as a provider for patient Smith, calls and asks to discuss the patient's care. So, staff member, Somebody can take this. Do you forward the lab results that Dr. Gove requests for that patient?
No.
All right.
Why not?
Because
It's not listed.
One at a time, one at a time. So everybody raise hands.
Because the
Or
patient
Janine.
lists him as his primary physician.
Okay. And you have no evidence that the person's involved in the treatment of that
Absolutely not.
person?
And it's
Okay.
not noted on a progress note or anything in the patient's chart.
Perfect.
Question?
I had a case, the provider wasn't listed on the chart, but the patient said that we actually referred him to the cardiologist. But it wasn't on his chart or anything, you guys had to have him go get like EKG or clearance from them. In that case, I mean, it's not in his chart.
Did we document that we sent to cardiology, or the patient said we sent them to cardiology?
You said you guys referred him to that.
That's good for
office.
us to hear, because at times clinically, I'll just write on a script pad for the patient to go to cardiology, and I may not throw that in my note of detail, so hearing that, I'll throw that in. the
So
note.
let's go to the judges. If it's not documented, did it happen?
Never happened.
Never happened.
No matter how good your memory is, it never happened.
And we look really bad if it did happen. We look really, this goes to the doctors, we look really bad if it did happen, and that's an avoidable error. All right, so for the doctors on that question, Gove then says, well, I'm really taking care of this patient, and he calls you directly. Can you discuss the case with Dr. Gove? Which doctor wants to take that one?
No,
No.
All right, Craig, no.
you cannot.
Why not?
Because again, we don't have any documentation that he is treating that patient until he signs a either HIPAA form for the patient or a medical request for his labs.
Question now, if Gove's on the phone, patient sitting in the exam room with Gove, patient says, I'm Mr. So-and-so, please disclose this to Dr. Gove.
How do you know it's not, how do you know it's the patient?
How do you know it's... No, I understand that, but doctor, if it's the wife asking that, I have a whole lot more suspicion than if I know Ron Gove and Ron Gove calls me and I have Mr. Jones in the office here. It's the credibility issue is your question.
So let's kick that up to the judges. How do you handle that situation? As Samantha said, Dr. Schutz can't be sure it's the patient on the phone asking.
If you're dealing physician to physician, I have much more comfort level because the physician, and I would just say you recognize that, I'm giving this to you for purposes of treatment of this individual, which I'm allowed to do under HIPAA. If you're doing it for any other purposes, I can't be doing that. And then presumably Dr. Goth would say, yes, I'm treating this individual. Because you don't need, for doctor-to-doctor exchanges or exchanges between JUG and another medical practice, if you know somebody's involved in the treatment because they were the primary care physician and they sent them over, you can send the information back. There's going to be nothing in writing to that effect because you're doing it under the guise of treatment, and the law allows you to share information for purposes of treatment. If you have suspicions that somebody's really not treating that person, then you put your antenna up and you think, all right, how do I make sure to verify that? But if somebody's involved in the treatment, you can do that. If a doctor's calling another doctor, I have much less hesitation about that.
So let's say Victor Cruz comes to the hospital after the Eagles game the other night. He comes to the hospital.
You're in after his...
And you want to go look at his chart, but you're not involved in his care. Can you?
Violation of HIPAA privacy, because you don't have authorization to go on his chart.
Even though you're a provider, you're not his provider.
And that goes to one of those situations we talk about, that even within your own organization, like at a hospital or something, only certain people are authorized to look at things.
Now, we do audit log here, and if one of us is a patient and you look at the chart, we will be able to identify that via audit log. So only open the charts in which you're actively involved in their care. That's my best recommendation. Would you guys agree?
There are people who get fired from hospitals in Los Angeles and New York all the time because they access a celebrity's file when they had nothing to do with the care of that individual.
In fact, they entered into a big multi-million-dollar settlement, I believe, on that specific issue out there.
All right, number 2. This is also for the staff and for the docs. Mrs. Smith's husband calls and gives permission to speak with Dr. Schutz as his wife is at work. So the staff, can you forward results to Mr. Smith if he says his wife's at work and he wants the lab results?
Not if it's not on the HIPAA form.
They can go
We don't give labs out anyway.
Yes. First, we're not allowed to give lab results over the phone. Second, they would have to come in and sign a release of records form to get that information.
Wait, portal.
And who has access to the portal?
Only the patient.
Only the patient.
Well, that's not always true.
Yeah, or.
Well, Carol, so you're saying the patient gives their portal access to someone else? All right, so Carol's question, everybody, is, if Carol gives their access to someone else, are we violating their privacy? To the judges?
Patient can do whatever they want. We would tell the patient
We
they
don't
shouldn't be
even know.
doing that. But we can't be the mother or father or police for what patients do or don't do. The patient can voluntarily give up their own rights. That's their choice. We can't give up the
Can
patient's
we
rights.
get a HIPAA over the portal? To add people under their HIPAA?
Doesn't HIPAA have to be done in person? No, if the patient was actually filling it out. Because
Well, you just said, I can't be the mother if they've
You
given
can't
their
control what a
log
patient
on.
might do, but are they allowed through the portal to change that type of information?
Oh, that's what I'm asking.
They're not allowed to do it by figuring it out on the portal, but if they ask one of us to send it, I mean,
I tell them to come into
That's
the
different.
office.
Our general rule is whenever anybody asks for things, we like to do it in person so we could visually confirm the person who's making the request matches their photo ID.
That's right.
All right, let's see here. Dr. Bernal is at the hospital. You're at the hospital and you lose your patient list.
After you say that, right, then what do you do?
What do you do? Walk me through the steps of what you've just done.
First you try to find it.
I was gonna say after he's.
Assuming you can't find it, and you think you left it at the Eagles game.
Right, so I mean, I guess I'm supposed to figure out who's on that list and contact contact them all and say, hey, I lost your list.
I lost your name
I
and
have a
contact
piece of paper with your name on it and identifying information that you were in the hospital.
Isn't he
Tell
supposed to
Danielle.
notify Danielle?
I think I would answer, and you guys will give the final judgment. Step one is you notify Danielle.
Right.
Step two, she'll come to me and I'll come to them, so we can then make a formal notification of the patients. So even though the answer is notify the patient, I think we have to do it as a concerted effort to make sure we've done it properly.
And step 1A is if you did it in the hospital, talk to somebody in the hospital to make sure if somebody in the hospital finds it, housekeeping, another doctor, if you drop it in the lounge or something like that. The thing is you can avoid having a paper list.
Impossible.
What if we lose the laptop?
Code Hero, when actually Craig just said it's impossible. When Code Hero, the new system, finally comes online, it will make a need for paperless go away. Because you'll have a password protected device like an iPad that nobody can get into that has your list.
2 years and going.
All right, so now, let's pick a judge staff. Since you're standing right in front of me, I have to ask you. You accidentally give a document with somebody's billing information, including what procedure they had, what their diagnosis is, and what their charge was, to the wrong patient. What do you do?
Tell Danielle.
Same process as Dr. Bernal. Don't tell Carol, she'll be very upset with you.
No, I wouldn't.
No, you're right. Do the same process Dr. Bernal did. All right. Let's see here. Megan. A jug staffer accidentally splashes you with urine out of a urine machine.
Oh my goodness.
Urine?
With urine. Not your own. What do you do?
Immediately go to the bathroom, wash myself thoroughly, and then notify Danielle.
Judges, what would you say?
That's a good answer.
I think on any fluid exposure,
Wash my hands.
on any fluid exposure or any needle stick, you've got a couple resources. Number one, do not keep it to yourself. Number two, in the case of chemicals, you may want to ask a question, but wash. The solution to pollution is dilution. So immediately try to wash the affected area. And you do have a resource right available to you. You should have a MD literally within a few feet of you. Don't ever be afraid to ask about an exposure issue right there. And I would also recommend going to Danielle so we could activate our process.
We do have OSHA, manuals stating what to do in case of a splash or, digestion.
Yeah, and if it's something like a needle stick or that gets more severe, there'll be other steps taken to make sure, tell somebody and you will be assured you will get the medical care that you need should it be a more severe issue.
All right. Next one, Dr. Schutz. A judge staffer begins to talk to you about sexual intercourse that person had with their partner. What's the appropriate response?
That is inappropriate conversation here in this office. I don't care, I don't want to know. Keep it to yourself, talk to your partner about it. It's not appropriate conversation here.
I feel like that's all.
Would you guys have any additional comment?
Nope. That's nailed
And
it.
I would add, if you do feel uncomfortable, I would go immediately report that either to Danielle, to Jessica, to Melody, or if you see one of the JUG partner docs, go immediately to them. Come to me. Let us know if you're made to feel uncomfortable.
What if one of the staff members has a question medically that
That's what I was
involves
just gonna
speaking
say.
about that? Is that inappropriate as well?
They're asking medical questions while
Like my husband's having difficulty with his erection.
Then he needs to make an appointment.
Pain within her.
Pain with intercourse.
Actually, that's a great question. You know, for me, if you have a medical issue with it, I have a little more comfort with talking about it. I don't want to know your personal issues. That's a medical issue, not a personal issue.
But you don't maintain a chart on that patient, so you can't talk to them about it.
Exactly.
No, they're talking to me about their medical problem.
But you don't maintain a medical chart on that.
They're not a patient.
So how are you giving them clinical information without maintaining a chart?
So Bruce, let's go to the judges. I'm gonna ask the same question about a curbside consult. If I don't document, did it ever happen?
Never happened.
That's to your point. So should Dr. Schutz in that situation, because he's now giving clinical advice, document the advice he gave?
You should document any advice you're giving now, or say, listen, I'm just telling you informally without ever treated your spouse, significant other. Here's some things that you might want to do if you want to come in and have an appointment. We'd be happy to have a more formal appointment in terms of doing so. And obviously, if you're raising that issue, don't raise it in the hallway. Go back and talk to the doctor in a private room, so that conversation's about your partner is not getting heard by anybody who might be walking past.
To your comment about you're saying that it never happened if Schutz doesn't document it, well, if the person documents it that they spoke to, it happened.
That's right.
So as a physician, you can't give your medical advice without documenting.
I mean, people are going to ask.
People ask all the time.
People ask all the time. I get all sorts of questions as a lawyer. People ask me about things that I may or may not have any clue about. If you're having a conversation with somebody, say, listen, I'm not giving you formal advice because I haven't treated you or your partner, but here's some things that you might want to be aware of or be cognizant of or look to see if there's any follow-up symptoms relating to. And then if you need to, certainly you can make an appointment in the office. I mean, we're not telling people to not talk about knowledge that they have. You just have to make sure you're not creating a physician-patient relationship with one of you is asking an issue about your significant other.
For instance, AIDS. Somebody comes in and says, I get urinary tract infections after I have relations. I'm not giving that person antibiotics. You may need to go talk to your healthcare provider about that. But I'm not going to give somebody macrodantin to take every time they have relations. That's not going to happen. So because the other thing is our documentation is not just for the health record, it's billing. I'm not going to bill for that because if you don't have a record and you submit a bill, that's fraud. So that ain't happening either.
I think a good take-home message is, especially when dealing with patients, and this applies to everyone with every situation, no matter what you talk about with a patient, it should get written down. If a patient says something that sounds, especially if it's out of the norm, you should have documented that somewhere in a note. We've had that issue come up numerous times, and the notes that have been left by you, whether it be the staff or the provider, have been of enormous help to us. So don't be afraid to, if a patient says, write everything the patient says down. No matter how off the wall it is, you're not there to make a novel about how wonderful situations. If they say X, Y, and Z, you copy them verbatim and say that's what they said.
So even if we're in a patients and we have a urologically related issue that we want to discuss with one of the providers here, it would be in our best interest, just so we have a medical record of it for ourselves, to make an appointment with you.
I think you can make an informal appointment, but you should at least pull that provider into a room and say, can I ask you a private question about my own medical health? That way everybody in the office isn't listening to your medical issues.
And if it's something,
that was my.
and if it's something more significant, where one of the doctors says, listen, can I examine you? That's a different scenario as opposed to just giving you some type of advice, just here's some things that you ought to think about if this occurs again.
Because I know I'd want it on record, so I could refer back to it.
I'd like to thank you both for coming today. Like I said, if anybody has any questions, please forward them.
If the progress note says like the doctor will refer the patient to a cardiologist, but it doesn't have the cardiologist's name, and they call for.
And the cardiologist says, I got the patient, I think you have to make the presumption, like Bruce said, that person's involved in the patient's care. But again, that's a great situation to point out when it happens. You email to me and I'll correct all the doctors saying, you put a staff member in a difficult position. The doctors have to be precise. If you're saying to a cardiologist, I referred to a cardiologist who the patient hasn't chosen yet, but who will call us and contact as soon as they, know it is. You have to educate the patient. All right. Thank you guys so much.
Thank you.
Thank you.
Can everybody please hand these up here to the front? Thank you guys so much. You know what it is? It's a frame.
We're getting some sort of screen provider. As soon as we go on.
What is he somewhere?
Thank you all.
My notes. Thank you.
Don't want to know.
Can you give us a hand? Can you take the old chairs back into the billing waiting room? The black chairs stay in a U shape, and you have to move on. Make a U shape for the doctors.
Is this on?
Do you want me to stop this camera?
I don't like the way it sounds on that.
Yeah.